So you lost your motion to dismiss, your motion for summary judgment, your motion for judgment as a matter of law both before and after the jury verdict. And your judge refused to grant you a new trial. Now what? Well, of course, you can appeal. In general, in order to appeal, you must have either a final judgment or an interlocutory order. We'll discuss each in turn. You have to file your appeal within 30 days of the entry of judgment or the interlocutory order. However, if any party requests reconsideration under Rule 50B or a new trial under 59, or any of the motions mentioned in Rule 4A4 in the Federal Rules of Appellate Procedure, the 30-day clock starts from when the judge rules on the last of those motions. The purpose of the final judgment rule, defined by 28 U.S.C. 1291, is to avoid piecemeal litigation. We don't want the parties bouncing back and forth between the trial and appellate courts every time the judge does something that one of the parties doesn't like. A final decision is essentially one that ends the litigation on the merits, such that all the judge has left to do is enter the judgment. However, that doesn't mean that the entire litigation must be over before an appeal can be filed. If a case involves multiple parties or claims, once the court renders a final judgment as to any one of the parties or claims, and certifies that judgment pursuant to Rule 54B, that judgment alone is appealable even though the rest of the case is going to continue in the trial court. Similarly, the parties don't have to wait for resolution of all of the collateral issues before appealing. For example, if attorney's fees and court costs were awarded to the victor, but the court has yet to consider evidence relating to the amount of those costs and fees, the loser may nevertheless file an appeal on the merits, because the fees and cost question is collateral to the merits question. In addition, there are a few judge-made doctrines that expand the final order rule, essentially making non-final orders final orders for the purpose of the final order rule. But they're pretty narrow and not likely to come up in your Civ Pro course. Here are two simple examples of what is not an appealable final order. One, the denial of a motion to dismiss or summary judgment. Those are going to allow the case to go forward in the trial court. Needless to say, a grant of a motion to dismiss or summary judgment is a final judgment, and therefore certainly appealable. Number two, an order requiring a party to correct a technical violation. He messed up the complaint because he didn't understand the rules properly, so the judge said, go fix that. No harm done. The judge is going to allow the litigation to continue if the party complies. That's not an appealable final judgment. We said that in order to file an appeal, you either need a final judgment or an interlocutory order. Interlocutory orders are appealable by right if they relate to certain issues. It's a short list, and the only one that you're likely to need to know is a request for injunction. Whether the court grants an injunction or denies an injunction, it is an interlocutory order by right and therefore appealable. Otherwise, and far more commonly, the judge must certify the interlocutory order and grant the parties the right to appeal it. Once the district court enters the interlocutory order, the appellant has just 10 days to seek an interlocutory appeal. In order to satisfy an interlocutory order in order to certify an interlocutory order for appeal, the district judge must find that the order involves 1, a controlling question of law, 2, about which there is substantial grounds for difference of opinion, and 3, that an immediate appeal from the decision will speed up the termination of litigation. That has to be a controlling question of law. It has to be important to the case. 2, about which there are substantial grounds for difference of opinion, which means that the appellate court is likely to disagree, or at least there's a good chance that it will. And 3, the fact that it might disagree and that it's a controlling opinion, by sending it, given that fact, by sending it to the appellate court, we're likely to speed things up. Because if we wait until the end of the litigation, the question goes up to the appellate court and the appellate court disagrees, we might have to come back down to the trial court and redo a lot of the litigation because that controlling question of law changes the flow of the rest of the litigation. Generally, interlocutory appeals are disfavored because they are seen ultimately as slowing down the litigation. So you actually need a pretty good showing that allowing the order to go through is going to speed things up. Interlocutory certifications, when not made by right, are discretionary. Both on the part of the trial judge can decide not to certify the question, and on the part of the appellate court, which means that if the appellate court doesn't want to hear the appeal that's been previously certified by the trial court judge, the appellate court can say no thank you and send the case back down to the trial court.